time, right? We have a certificate of appreciation for him, don't we?
He's saying no. He's staying?
I don't think
No?
I'm over yet. I think I'm
Okay.
holding over until they find a replacement in June, I think is my last. Yeah, official. Is that right? Is my last official meeting in June?
Okay. So we'll hold the certificate.
No worries. We're still gonna do it now.
Oh, we're still gonna do it now. Okay.
Yeah, if I can have the floor
Yes,
for a moment.
please.
We are gonna do a little honoring now because if somebody comes to fill that position sooner, then they will come in. So there's no guarantee. So
Okay.
like to do is on behalf of the Leeward Planning Commission, the Planning Department and the mayor wanted to appreciate you and your service for serving on the Leeward Planning Commission, gone through many applications, many processes, and really appreciate your dedication, showing up, being very knowledgeable about the content. And so with that said, we'd like to provide you with a certificate of appreciation. Everyone. So huge mahalo and one more. Get away.
Oh, very.
Thank you for your service. Speech.
Well deserved.
Thanks, everybody, commissioners, all you guys, staff. Fun working with everybody over the years, for sure. Appreciate it. You too, Sid. It's been fun.
Okay, continuing on from the Office of Corporation Counsel, we have Sinclair Salas Ferguson.
Aloha.
And we also have Deputy Corporation Counsel Jean Campbell. Representing the Planning Department, we have Director Zendo Kern.
Aloha.
And on staff, we have Program Manager Maya Jackson,
Aloha.
Planner Alex Roy,
Hello.
Planner Tracy Camero, Commission Secretary Noriko Sawyer, and Janice Hata as our Zoom host in Hilo. I don't see any yellow cards, so I'm not thinking we have any. I will check some. Okay. So there's no one here. Okay, is there any Zoom people that are going to testify? Janice, do you?
No, Chair DeFranco, there are no Zoom testifiers at this time.
Okay, thank you. So I just want to remind everybody to speak directly into your microphone and remember to mute it when you're not speaking. And please to raise your hand to be recognized by the chair before you start speaking. All right, so the first thing on our agenda is approval of the minutes. Review and approval of the minutes of March 16th, 2023, Leeward Planning Commission minutes. Are there any corrections? With no corrections, I need a motion to approve.
Move to approve.
Second,
Second.
yes, so any opposed? No, so motion is approved. All right, the statements from the public, so we don't have any. So we're right at new business. Okay. The introduction of the agenda items. So this is the applicant, D&L Fujimoto LLC, PLSMA 2023-000027. Application to amend condition number 7. Public parking requirement of special management area, SMA use permit number 51, SMA 51. To clarify the management and the use of 20 public parking stalls located on a 1.468 acre parcel situated within the SMA. The subject property is located Mackay of Kuakini Highway along the south side of Hanama Place in Kailua Village at 75-5722 Hanama Place, Keopu 3rd, North Kona District, Hawaii TMK 37-5-007-033. So we're going to have a staff presentation from Alex Roy. Thank you.
Good afternoon, commissioners. Today I'm here to present special management area use permit application, PLSMA 2023-27. This is for D&L Fujimoto LLC. Here's the location of the proposed request. It's a parking area right in the middle of Kailua Village. As you can see, it's Kailua, there's the bay. And most everybody should know where that is roughly. But right here in the center of Kailua Village. The applicant is requesting to remove condition number 7.
Excuse me, Alex, will you put this closer to your mouth?
Oh, okay.
Sorry.
The applicant is requesting to remove condition number 7 of the public parking requirement of the SMA use permit number 51, which was approved in 1978. Condition number 7, for your reference, states that the parking stalls on the Mackay side of the proposed building shall be clearly identified as for being for public use. The applicant is still committed to providing public parking at this location, but is requesting to be allowed to adequately manage the use of those 20 public parking stalls located on the subject parcel. A little bit of background, the condition 7 was set as a requirement of approval for an SMA to develop a commercial property. During that time, 1977, 78, there was a lot of questions about parking in Kona and for Kona Village. So the intent of the parking requirement was for economic development. It is not tied to any resource, cultural or otherwise. The intent was to provide parking for people to enjoy Kailua Village specifically. Here's the county zoning. We can see that it's commercial, village commercial, mostly all around the project area with some residential located Malka. The green is open zone, and here you can see Huahihi Palace. This is the palace. Hulahe, sorry. State land use, urban. Lupeg has this as resort node, the subject property, and then Malka would be a medium density urban. And then of course you see along the coast is typical open for Lupeg. Here's an aerial photograph. So I know there's a lot going on here. So I highlighted the subject property in the dashed line and then outlined the parking area in yellow. So you can get an idea of roughly where it is within the larger area. Here's another shot from the other direction. Again, this is an apartment building here. All commercial development with some residential, but mostly commercial development surrounding the area. And you can see, I'd like you to take note of all the parking. There's a lot of space down here that's given up to parking. So again, outline of the property and then the outline of the specific project area, essentially the parking, 20 parking stalls. Here's a site plan that was provided. This is kind of out of the 1978 approval, just showing you a basic outline. So this is in line with what I just showed you. Here's the parking, 20 parking stalls. So this is kind of the area we're focused on today. Here's a photograph from 2017. One example, I have a few. I just put one example of some of the issues the owner has to go through. Here we can see this, vehicle has no tire. It's been lived in, destroyed, and I believe the landowner had to pay hundreds of dollars to get that removed as a junk car. But this is one example, and I believe you would have gotten some testimony showing you a very recent, I believe it was on the 18th. Yeah, there was some damage done to the vehicles, spray painting, things like that. So as is often, when something is free and unfettered, it gets abused quite readily. Now, not to say that this is an enjoyed, people enjoy this, and obviously every picture I've looked at, the parking lot has been full, so it's definitely used. But we can see that there needs to be some measure of control, otherwise it gets abused and things like this will happen. And this is not even the worst picture. Here's just a kind of up close site photograph of the parking area. So you can see how close it is to an apartment building. We received some testimony from people who live in the apartment who noted, issues with what goes on there. The common drug deals, loud noises, breaking and entering, things like that. Here's from the other side. So from Sorona Road, you can see the parking lot. I pointed an arrow to showing where that parking lot is, or the 20 parking spaces, essentially. So the entrance off Sorona Road, and then there's an entrance off the other side. Here's the entrance from Hanama Place. Right at the end there, of the turn on Hanama Place. So there's two entrances in and out of this parking area. So at this time, the director is recommending that PL SMA 2023-000027 be approved with stated condition. And I'd just like to say, why did I not add an S? Because we removed the conditions from the request and added only one, that they have to adhere to all relevant laws that they may come across in the future. The reason that we deleted all of the previous conditions is that they have all been adhered to. They've all been completed. Conditions like request, plan approval, other issues that would, to put them back up on this new request, would essentially, they were moot. They're no longer really valid because, again, they've all been adhered to. So that's why we went ahead and just deleted all of the conditions along with 7, and then added just the single condition that they'd have to adhere to all rules and regulations. I could take any questions at this time.
Commissioners, do we have any questions for the county?
I'll wait till a motion is made. We can have a discussion.
Wise man, okay. All right, well, thank you, Alex. Thank you, Mr. Roy. I think we're going to have a presentation from the applicant and his representative, Mr. Fouquet. I just have to swear you in. If you tell the truth today in front of our commission,
Yes, I so affirm.
and just state your name and where you're from.
Sure. Good afternoon, Madam Chair, members of the commission. My name is Sidney Fouquet. I'm a planning consultant. With me tonight is the applicant, this afternoon rather, is the applicant, Mr. Daryl Fujimoto, and he's just sitting in the back.
Okay, and
Um,
you've received all the background and the the recommendations, and do you
Yes.
agree with the recommendations? And
Yes, we've reviewed the staff's written background report and the recommendation, and I reviewed it also with the applicant, and he's totally receptive and accepts the recommendation. We found it to be very comprehensive, and the videos kind of like speak for themselves. If I may, Madam Chair, I'd like to kind of like just digress a bit and talk about the whole project.
thank you.
But before doing so, I'd like to again offer congratulations to Mr. Bitusek for his untiring service for the Planning Commission. And quite honestly, he pointed at me, but it's true. Like he gave me a lot of sleepless nights, before appearing before commission and even subsequent meetings. But I think that in the end, it forced us to really think hard. And so in the end, I think a lot of good things came about. So thank you very much, Mike. So you'll be missed, but in a different way.
From the friction comes the pearl, right?
That's true. The other thing I'd like to kind of mention, and this is like full disclosure, because when this permit was approved, I was sitting where Director Kern was sitting. I was a planning director at that time. So I kind of wanted to give you some background in terms of how this thing came about, and such that, I don't look like a hypocrite. One time I say this and now I'm saying another thing, but, hopefully as I go through the presentation, you'll have an understanding of why, I've kind of like changed my position, relative to this application, because otherwise I wouldn't be here because we're too hypocritical. anyway, like in 1975, the state passed the Coastal Zone Management Act. And that kind of like emanated from the federal government. The federal government said, look, state, if you pass this Coastal Zone Management Act, then we'll give you guys a lot of funds to implement, so on and so forth. So it was kind of like an incentive for the state to pass the Coastal Zone Management. And so a number of coastal states like Alaska, California, Maryland, Florida, they all adopted Coastal Zone Management programs. So in 1975, the state adopted it. And then in 1976, which is a different matter now, as part of the planning program, we developed and then ultimately was accepted by the commission, this Kailua Village Design Plan. And in that Kailua Village Design Plan, it had earmarked this particular area, not necessarily this parcel, but portion of this area to be set aside for so-called public parking use. And the reason being, like, taking you back again into like the early 70s in Kailua, that area was bustling with a lot of tourists, but never have any parking. Since that time, the county acquired some properties and then they have a public parking area, in the vicinity of Kailua. But anyway, that's the Kailua design plan that was adopted in 1976. So then in 1977, pursuant to the state SMA law, there was a requirement that the county must establish where these boundaries are going to be, your SMA boundaries, and establish all of those rules. And so by June of 1977, the SMA boundaries were adopted. The boundaries when they had adopted, they had said like initially it could be like 500 feet, or if you look at major highways. And so what happened was that when you looked at the major highway approach, this is when I was sitting where Zenda was sitting, we looked at Queen Kaumana, we said you use that as a benchmark. And you came into Kailua and then you continue on to Kokini Highway and you went all the way to Kyoho. And then from Kyoho, then the line kind of dropped down, to like about 1,000 feet. So anyway, that's the SMA boundary in 1977. So shortly thereafter, the landowner submitted their plans to construct a supermarket. Actually, it was Foodland. So Foodland wanted to build a supermarket over there. So they come in with the plan, but lo and behold, now they're in a SMA. Had they applied like before June of 1977, they would not have had to deal with this kind of SMA type of issues because it was permitted within a resort zone. But the rest is history, and SMA was required. So in January of 1978, one of the first major SMA permits that was approved by the Planning Commission was this project. And so me sitting where Zenda was, and it's like, well, the Kailua Village Design Plan talked about like, we should have some parking, here and there. So I said, that would be a good idea if we can convince the developer to provide parking in that area. And so the developer said, fine, like on the Makai side, we'll reduce the size of our supermarket, and this Makai portion, which consists of approximately 10,000 square feet, was set aside for public parking. Okay, so what happened was that when the SMA was approved, that condition became part and parcel of the project. So anyway, so if you look at the background report, it says like the condition was the parking stalls on the Makai side of the building shall be clearly identified for public use. The rationale that was given for why it was that condition was to enhance the economic development of Kailua while providing partial solution of the parking problems in the area. So there was no direct correlation between the SMA objectives policies, but just say it's something that's needed in the community in that area. So anyway, like in 1979, the project is completed. Woodland moves in, the 20 public parking stall. And for over 40 years, what has happened is like, you've seen like some of the photos, you've had like abandoned vehicles, vagrancy, homelessness, drugs, trash, security, vandalism. And then for some, they've kind of privatized the stalls. There's some condos over there. So even though they park there, assuming that that's their stall. So anyway, so this is the situation where the prior and the current owner have had to deal with all these 40 plus years. Current owner acquires the property in September of 2021. That's about 2 years ago. And then he still allowed the continued use of that area. Then he brought up all of these issues to me and he said like, we gotta have some control. We cannot just say, let the public or whatever use, and then look, all of this. I've had to bear the problem of removing these abandoned vehicles. I've had to pay the insurance. I've had to assume all the liability and all of this, and I've had to pay the real property taxes. And the county has not paid me a cent. So the question is like, was it fair? So when he approached me and, told me in different ways, not in that manner I'm describing it to you, but he said like, oh, so then I thought about it. I said, yes, since 1977 or 78, when that decision was made to now, we've had a lot of judicial decisions made, which have kind of provided the focus in terms of what discretionary bodies or agencies like the Planning Commission can and cannot do. And one of the major ones as it relates to the County Planning Commission activity was Topless versus the County Planning Commission in 1993. So this is a property out, by Kona Sea View, commercially zoned. The guy comes in with a bill, but you remember I told you like the SMA line was all the way up to Cool Kitty. So he was right at the corner of Cool Kitty and the Sunset. I forgot the name, but right in the commercial zone, he comes in with a 2-story condominium apartment complex. Well, the commission hears all this issue about traffic, from the neighbors and all that stuff. This is before traffic lights over there. And so the commission denies it. So on appeal, the Intermediate Court of Appeals basically told the commission there was no rational nexus between a traffic issue and your SMA objectives. And so basically said like, commission, you went beyond your boundaries. And so that was the top of the decision again in 1993. It's a decision that wasn't there when I was in planning director. Then the other one was like, the second issue was like, this whole notion about takings. Takings is like when you require a public use of a private property without just compensation. And that would be in violation of the Fifth Amendment of the Constitution. And since that, since 1978, there were 2 significant judicial decisions. The first one was what is called Nolan versus California Coastal Commission. California Coastal Commission is equivalent of the Planning Commission, all pursuant to the CZM law. So in 1987, this guy wants to tear down an old bungalow. It's a shoreline property. He wants to tear down the building and build a house. So the Planning Commission said like, oh, there's a shoreline access and all that stuff. But if you build that, it's going to block the view, and there's going to have like a psychological impact on people not wanting to use the shoreline because, we cannot see. And so the commission then essentially said like, okay, to offset this burden, we're going to require a lateral public access on your property. This is in Ventura, California. So the guy said like, oh, went all the way up to the Supreme Court. And the US Supreme Court said, you know what, there was a taking. There was no rational nexus in terms of what you required and, the impact of that project. So that situation was pretty much similar to the Topless one, except the Topless related to the state of Hawaii. This one was in the state of California's US Supreme Court decision. The other one was Dolan versus the city of Tigard in Oregon in 1994. And here, like, it wasn't a shoreline property, but the guy was trying to build something along this public, this greenway along a riverside. Mm-hmm. And then the decision makers at the time of building permit says like, you know what, you have to provide these public pedestrian paths all the way along this coast, all along this riverbank area. So the guy appeals, and then the US Supreme Court, they said like, well, I think there's some basis for like the drainage issue, but in terms of like the right for the public to get access all along the shoreline, not shoreline, but that greenway, it's kind of questionable. So they introduced the concept of if there is some impact, then it's got to, your exaction has to be proportional to the impact. You cannot just require whatever, but it has to be proportional. So those 2 are landmark judicial decisions that essentially established the principle of, when it relates to whatever you're going to require as condition, first of all, rational nexus. Is there a relationship? Secondly, then if there is a relationship, you can determine there's a relationship, then what is the proportional obligation? The other reason why I've kind of thought about it, and think like, why, the staff's recommendation is on point. It's like the whole notion of, and I've kind of mentioned this earlier, it's about equity, fairness. So this guy, it's Foodland, but it's Foodland then, big corporate, and now this guy, they own this building. But put yourself in their position. Say you have a property and 10,000 square feet of land, and the government tells you, you cannot use it. You got to pay taxes on them. You got to maintain it. You got to assume all liability. And that's what this condition did. That's what this condition. So I think if I put myself in that shoes for my house and they tell me I got to do that, I would say that's totally unfair. You have to pay me, government. If you want that established for the public, then somebody's got to pay me. So, but the county hasn't paid. There's no relief in the real property tax. He pays the real property tax as though that's all commercially zoned. So anyway, the last thing I kind of want to impress upon, this body is the whole notion of precedent. I know that, when you look at all the decisions that commissions have made relative to coastal properties, they've addressed things like public access. But public access, for the most part, to the shoreline have related to properties that are adjacent to the shoreline. In this situation here, you got to ask yourself, like, this is Hanama Place. It's not a coastal, it's not a shoreline property. So the question then is like, there's really like no need for a shoreline access over there. There's no historical trail that shows Mauka to Makai that a portion of this historical trail goes through this property. No. So the question is like, there's no public there's no access requirement. Then the question becomes like, well, what about parking then? So it's like, well, if you look at parking, will the commission require parking for all shoreline, all SMA applications, whether it's for a single family dwelling, commercial, condo, whatever have you along the shoreline? Will you require parking? And if so, how many parking? This is not to say that it's not unusual to have parking as part of a SMA requirement. You look at all of the major resorts up and down the coast. Manalani, Mauna Kea, Huanaiki, Kukio, Hualalai, they all have public access, and even Hokulea. They all have like public access requirements, and they all have some parking. But you got to look at the magnitude of the project. So that relates to the impact. What kind of impact is that project doing that generates a need for access, that generates a need for parking? So I ask you all to look at this and ask yourself, like, what is it about this project that he should be burdened without compensation, 10,000 square feet of land that you can put up a few homes or maybe an office building and generate some revenue? Where is fairness in all of this? So that's kind of like my pitch. And at the end of the day, this is Mr. Fujimoto, and he can come up and affirm, but he said that he still wants to keep it parking, but he wants to be able to manage it. Managing it means like it's going to put up like whether it's going to be managed by Diamond or whomever. So there can be some control and there can be some amount of revenues generated to the point where he can help with the maintenance, of that area. So in terms of availability for the public, yes, it would still be available. The question is like, you might have to pay a little bit. So, and with that, I say thank you and happy to answer any questions.
Thank you. I have a question for you though. So in all this time that they've had it, they've never done anything themselves to protect the parking lot because it's public parking. They can't put up paid parking right now. I mean, what's stopping them from? Well, wait, I'm going to ask him.
They haven't exercised controls
Yeah,
because
because you're not allowed
the
to
assumption it has to be available 24/7.
the public.
I could speak to a little bit about that.
Okay,
I did a timeline kind of going back through and starting in 1987 was the first time the landowner requested, some kind of measure of control. And throughout the years, the planning department and the mayor's office, in fact, reiterated that. And I'll just read some excerpts. Here's a good one from September of 2000 from the mayor's office. Vehicles parked in the area should not be towed away, nor should patrons parking in those stalls be required to pay. This is based on the condition. So that was everybody's interpretation of the condition over and over again. Up until 2017, Deputy Director Darrow wrote again, the parking stall should not be chained off, developed, and that without coming back for an amendment. So the county reiterated again and again over the past 30 years that the condition stands. And the only way to kind of change that would be to come back to where we are today. So it really wasn't the fault of the landowner. It was the county kind of reiterating that stance through official correspondence that, yep, condition is unfettered, free parking for the public.
Thank you. And so one more question too, just so I understand the actual parking lot, it sort of connects to a different road, right? Isn't it sort of a connector
So it's,
that
Yeah,
you
yeah.
can drive through and get back to Elite
Did we get that
Drive
map?
or up to Kukini or?
I think that road is called Hanama Place.
Yeah, Hanama Place,
Yeah.
right? But then.
And then on the
from
backside, Sorona Road.
Sorry, what?
Sorona
It
Road.
connects to Sorona Road on
Oh,
the
to
backside.
Sorona Road
Yeah.
on the backside, okay.
So this is
Hanama.
Hanama Place here,
Right, yeah,
and then Sorona Road over here. And let
Right.
me zoom in. I got a couple. So here's Sorona Road, the entrance. It's a one-way.
right. So the parking lot goes to
Yeah.
Hanama to
Yeah,
Sorona.
it does. It spans and then goes all the way. And here's the other side at Hanama Place, which is a two-way.
Right, so it's become a useful thing for the community in a way of connecting those.
Yeah, they can drive
Yeah.
through the parking lot. For
Yeah.
sure.
Yeah, it's actually sandwiched between those two roads.
Yeah, thank you. Do we have any other questions at this time?
One question,
Oh,
Sid, and
yes.
for the
Yes.
applicant, in regards to parking and like Diamond, would you be willing to entertain like what ParkLink did with the Kimmy family? They gave 90 minutes free to the local community. After that, you're able to park in there rather than just having a full paid parking situation. I know that's a big question of our community asking and taking back something that's been there for so long. Is gonna be, because I feel for what you want to do. I see it. I see the vandalism. I see the people abusing that parking area. Us as patrons, if you just want to go down to grab lunch, you can never get parking because I know people in the condo use it as their extra parking stalls and whatnot. And would you be open to that?
For 90 minutes, it would be hard to police that, because we don't have a
with,
full
with,
time.
with ParkLink, they have the guys already set up, same as Diamond. Diamond's next door. I think you guys might use Diamond already on your guys' property.
Yeah, we currently use Diamond, but I'm not totally gonna, be committed yet. There's another, ParkLink just came on board.
Yeah.
And they have like video cameras where it's policed a little bit better. So I might, consider them too. So.
Yeah, that was just a question, because I know that would be the community would bring that up in a heartbeat. They would ask, how come this guy, I commend what you did with that building. It looks a lot nicer than it's ever looked.
Yeah, I'm
Homeless
trying
not
my
being around.
best.
Yeah.
This is one of the last things I need to do. So, yeah, it's gonna cost me a lot of money to repave it and stuff like that. And I know that, that's gonna be coming out of my pocket, but I just wanted to try and keep it nice after that, without having more vandalism is why we're asking for this. So as
Definitely.
much as parking that we can charge to subsidize that would be helpful for us, you know?
Oh, definitely. I know that was something with the Kimmies when it came up. They shut it down and they brought the 90 minutes in.
Exactly,
Brought the
exactly.
98 minutes back in just because they did have a hard time and they were required to provide public parking. With public parking, it can be paid, but you know, they heard the cries from the community and they went to that 90-minute. And that was just something I was wondering if you're open to.
90 minutes is a little bit too much, you know, I'd be like open to maybe 20 minutes, you know, for somebody to come and grab lunch or something like that, because 90 minutes, like somebody come in there and park and they come back for another 90 minutes, you know what I mean? It's really hard to police that.
Yeah.
I would rather not have any restrictions if possible, but I'm gonna still open it to the public so that the public can park, you know, there.
Yeah.
Because it's really close, you know, it's only 300 feet away from Ali Drive. And once you come out of Ali Drive to Serona and you walk that back way, you're in the center of Kona. Kona Inn is right there. So it's a really convenient place for the public to park, and we have no objections to it. And the public has been parking closer to the road, Ali Drive, as much as possible, because they don't want to walk up on the hill. Even though there's parking around that area that controlled by Diamond, there's a lot of parking, but not too many people park on the upper side because, you know, people don't like to walk uphill. So our place is really convenient. So for the convenience factor, I think that would, would be feasible for them.
Yeah.
Since it's closer, and I'm gonna open it up for them too, you
Yeah,
know.
that's just a
so,
question I wanted
yeah.
to ask, because I know that'd be.
No problem, no
something that
problem at
would
all.
come through
I
the
just didn't think that's a win-win situation for both. I try to look at win-win situations for both, you know, the public and us.
Yes, thank you. for-
You're welcome.
for your
You're
answer.
planning to keep it as parking.
Yes, I am planning to keep it parking and open to the public, you know. I want to, because, you know, the restrictions in the parking, like how Uncle Billy's, a lot of parking went away from there and a lot of people got mad, and a lot of people work in the, you know, the local people. So I want to, you know, leave it open to the local people also. And if they want to do like monthly passes, if people work there, you know, I want to give them a good deal on it too. But I also don't want to be taken advantage of. After 40 years of free parking, that's a lot of parking for 40 years. And we've been maintaining, you know, the property for that long and paying property taxes for 40 years and never got exemption. Not me, but, you know, the prior owner, but I'm doing it too now. So we're just trying to minimize the effect, but maximize the use.
Thank you.
Sure.
But you did buy it knowing this condition existed, correct?
I did by
Okay.
knowing this, yes.
Commissioner Knowles?
Pardon me?
Just in my experience, even the paid parking lots there are struggling with this issue of public safety and vandalism. What is your theory on why this change would have an impact?
Well, I'm gonna put security cameras now. We just got vandalized a few days ago. So being that I'm gonna have cameras on both sides of the parking lot, I think that would discourage more vandalism. Now that we have people on camera, there's no security out there whatsoever right now. So I'm planning to put cameras on both sides of the parking lot so we can see people going in and out at all times, 24 hours. So any vandalism occurs, you know, we'll have them on tape.
Do we have more questions? All right, so then we're gonna need, one more question.
And are you thinking about sort of comparable market rate?
Yes, we're
of
gonna be
what downtown
competitive.
Kona? I think I parked there a couple weeks ago and it cost me $12 for half an hour.
In our place?
No, just like in the,
Yeah.
in
it's not
the
our
public
place,
parking
no.
lot
We-
in
We're
Kona.
gonna be competitive
Downtown.
with whatever the market is.
Okay, if there's no public testimony still, okay. So we need a motion for action to discuss.
I move that the application for amendment to special management area use permit docket number 2023-00027 be approved based on the planning director's recommendation, which shall be adopted.
Second.
Second by Commissioner Canua. Okay, now we can discuss it. With questions.
Okay.
Commissioner Fatusek.
Thank you. Okay, I use this parking along with lots of other people who are using this parking in order to access the coastal zone. Surfing, fishing, those other things where there isn't a long time period, heavy fees for parking for a long time. You can park here, you can go down, serve fish in the bay when haul lure in. I'm concerned that if you look at this as assessing it against the SMA criteria of adverse effect, this would meet 9-10H2, which could curtail beneficial uses of the environment. So for us in the community who are using this to access the ocean, which as you stated is 300 feet away, along what I consider a historic trail of Serrano Road, I see that there's a profound benefit to the community and to the coastal zone to having free parking for community members. That said, I wouldn't fault you on trying to regulate that. I just would want to know more about the plans that will be put in place to regulate that. In other properties, we usually see something like a public access and parking plan that would indicate what the strategy would be that will maintain the beneficial use of the coastal zone, but also providing the control that the landowner needs. Is that something that you guys would be willing to consider, preparing a parking plan?
It's pretty much like what everybody else is doing.
Well, as Mr. Fujimoto had indicated, like in terms of the ability to control, manage it, I guess it's just like whatever is the prevailing, like parking controls that's in this area, in this particular area. I think in response to Commissioner Kanua's comment about like whether it's going to be, 60 minutes or 90 minutes, gratis or 20 minutes. I mean, these are the, the so-called the devil in the detail kind of stuff that he still has to kind of work out, balance that off against in terms of, if he's going to hire someone like Diamond or put in the lights, he has to figure out what the cost is, so it's kind of like a work in progress in terms of like how he's going to be implementing it. I think the critical thing is like whether this area is going to be set aside for public use, whether you have to pay or not, for public use, and then he's already made that commitment. It's going to be for public use. It doesn't say like whether paying or non-paying. I think the other thing, it goes back again to my earlier presentation about the rational nexus. 20 parking stalls, 10,000 square feet in perpetuity for public use without any compensation. Where's the equity in that?
Yeah, I mean, I look at it as the entire area being within the SMA and it being developed. We're looking at cumulative impacts from individual developments that have created so much development in an area that has limited the public's ability to utilize the coastal zone because there's limited parking. And so for this particular one, which you had the foresight of approving back in those days that created public parking to allow people, I mean, the stated intention at the time may have been for economic reasons, which may exist, but it also has served the purpose of allowing parking for residents to access the coastal zone, which, whether stated or not, is a beneficial use of that area. And as you stated in other areas where you have development in coastal zones and public access, there's generally a public access plan that is followed.
Could I say something?
Of course.
Okay. The
chair.
reason why we want more controls is, yeah, it was meant for that. But because of things have changed with the homeless, the drug addicts and abandoned cars, the people who are supposed to access don't have access. The condo next door takes up sometimes half of the stalls, so that Kona Plaza uses half of my parking lot most of the time. So the people it was meant for, it doesn't even have the access to the parking. So what you're trying to do and do free parking is still be abused unless I have the control over it. So that's the whole thing we're trying to get away from.
Sure. And what I'm suggesting is that you guys create an actual plan. When, Mr. Fuki said the devil's in the details. And I think
the plan would be just to be just like,
hold on.
Okay.
I think those details are important. So I think that being able to identify how you're going to control the parking, who's going to have access, how you're going to be able to do that, that's important for a landowner. And I get that. I think you should have that. But it's also important for the public access. So I would want to have a condition in here saying that you would prepare a public access and parking plan that would be approved by the director.
Can I jump in here?
You can in just a minute. So are you finished, Mike?
Sure.
Saying that, I just, wanted to make it clear, Mr. Fujimoto, we're here to really listen to everything so that we can understand it. So respectfully, we are trying to make this correct also for Kona, for you, for the county, for everybody. So you have to bear with us a little bit to ask questions that are not
Oh, no problem.
easy.
Sorry if I'm being a
sometimes,
little
but,
abrupt.
Our
just-
concerns is we sit here, we listen to what people say and we want to believe everything that we hear, but without a plan in place, without some kind of commitment like that, we could say, oh yeah, let's take this out, and you could do anything with that parking lot that you wanted if we took it out of SMA like this, I think it is a good thing to question that we have to be careful here. So just bear with us as we ask these questions.
Sure.
Okay. Commissioner Knowles.
Yeah, thank you. I agree. I think one of the concerns too along the takings argument, which is I understand that application, but I think, part of this access requirement with parking in other coastal zones, obviously that's something we have to do to preserve the public access, but this idea around the takings, I have a question because it seems like he has a valuable piece of property that he's got parking stalls for. There is a benefit to the landowner. Theoretically, he's getting compensated for, he's not getting direct payment, but patrons of his business or his building park in the stalls, arguably. So it's a little bit attenuated for me. Not that we're tasked with that, I don't think, but it's a little bit tricky, I think, because you're basically saying he has no benefit in that lot.
So
But-
if I can respond just generally to that, like if this were like part of the basic parking requirement, then that's one thing, to be able to control, even to be able to assess, you're going to be wondering like, why should you assess parking for something that's already required? He already has the required parking on the Malka side of the building. This is all extra. This is not part and parcel of the project's requirement. This is a requirement that came about as a result of the SMA condition. So it's, like, if you want, like, it's hard to come up with a specific, like plan right now, but, because as I mentioned earlier, it's kind of like evolving. You have to look at the cost considerations. The original when we submitted the original request, the request was initially intended to enable him to exercise control to the point of being able to have some fees assigned to that to neutralize the cost. He did not want to have like the total deletion. And I spoke to him earlier and he said like, he's willing to go back like to exactly what we had proposed in our application. And that application called for the retention of that and just saying appropriate controls, which may include fees to address public safety enforcement, and its maintenance may be instituted by the owner and or operator of this parking area. So that makes it clear that number one, it's going to be set aside for parking. So fulfill directly or indirectly, Commissioner Vituse was talking about like, coastal objectives. Okay, so, and number two is the ability to exercise control. That was primarily what his primary intent was, as I think your staff, Alex Roy kind of pointed out, up until 2017, they said unfettered control. And that led to all these kind of problems. So he said, give me the ability to control. I'll still have it set aside for public.
And I guess that is the question, right? Because he owns the property, but he's not able to enforce any controls,
Exactly.
which is,
Commissioner Fatuzek.
Sure. Oh, I just want to reiterate that having a public access and parking plan is what gives them control that doesn't step on the beneficial use by the public. Having these mutually agreed upon terms of a plan that we can all agree says, okay, this is how they can regulate parking and still provide the beneficial use of the SMA. As far as a taking, now, I'm not the attorney, maybe Sinclair would weigh in, but I don't think we can argue a taking in a case where the owner purchased the property knowing that the condition exists and that the condition was agreed upon by the previous owner. It's not like something that was imposed on them,
And we're not taking it away now.
but nothing's being added,
Yeah.
right? This condition exists as was agreed upon previously. This applicant purchased the property knowing the condition exists. There's no taking. This is an agreed upon condition of the SMA. It's just from here, can we make out a plan that works for everybody? And I think that the best way to do it is through that plan. Also, last thing I would add, as far as deletion of the other conditions, some of those conditions, I think you can change the wording a little bit, but not delete. Like item 3 calls for the petitioner shall submit a landscaping plan to the Kailua Village District Commission for its review and recommendation. I'm assuming they've already submitted that plan. So what we would leave on as a condition is complying with the approved plan. Would that make sense to the planning department and the applicant?
As far as satisfying the conditions,
Yes, as far as continued compliance with the conditions, the
we,
existing.
we have no
conditions.
problem with that. We want to,
Yeah. Yeah.
keep it looking nice.
Would that make sense to you, Director Kern?
I get what you're saying. I don't think it's necessary. I'm not, if it stays, it's not a big deal for me one way or another on that one. He has to comply with our landscaping rules, all of the other rules and regulations that are currently in there. And if he were to come in to change something, he would still have to comply with those rules. So by deleting those doesn't take away
Okay.
compliance with current rules and regulations or what was previously done.
But I mean, my reading of it is there's a specific landscaping plan that was approved for the property, right?
And that's in his plan approval.
That's in the plan approval. So they would have to continue to comply with that. Okay,
That's
that's
correct.
all I think. To me, it makes sense to leave it in there in case they decide to go cut the trees down for whatever reason, or, he sells it to somebody else and the other applicant goes like, oh, I don't have any landscaping requirements. I can do whatever I want.
And that's where the blanket condition at the bottom comes into place. Just like if you're dealing with a property that's outside of the SMA, they still have to comply with those rules, even though there isn't a explicit condition within a attached adjoining permit.
Right. I just feel like, again, that having that as a condition, saying that you have to comply with your landscaping plan leaves little doubt, and that it gives whoever would acquire it the knowledge that, okay, there is a landscaping plan that exists that I have to comply with.
Like I say, I'm good either way on that.
Okay.
So just that, I like, Mr. Fouquet, the proportional obligations that you spoke of, and trying to understand, like, in the history of this, I understand why it happened. And I do understand that he bought it as is, but I do look at this as he is trying to also look what's happened to the dynamics of Kailua Kona, of trying to make a parking place that's safe, that's clean, and is trying to come to some kind of reasonable conclusion. And I think that the way that I'm not sure if there's a way to meet in the middle. I mean, it's almost like if it's a public place, then he can't charge for it because it's public, right? Right. So he can't do anything about the cars being left there, anything being done there because it's public. He can't do that. Now he and the people before him and everything, this has been offered to Kona this whole time as free parking, right? And now it seems like it makes sense to look at this again and to see if he gets what he's asking for is to take away this part of commitment as a public parking and privatize it. Is that right?
That's correct.
I'm on the.
But still offer it to the public.
Yeah, and still have public parking.
Exactly.
Coming from a private place. And it's right, you go to have lunch down there and some people charge $12 for 30 minutes, while you're You know, so it is all of us trying to digest really what you're asking, because those are some of the few free parking spaces available down there. But we also have the vagrancy happening and the vandalism happening and the drug addictions happening without being able to do something about it. I don't know, maybe the community has moved this to the place it is right now, that we have to look at changing it to protect the community.
It's not safe over there. A lot of people are not, don't want to walk down there. But I fixed the lights. The lights were broken before, so they feel a little bit safer. But the people in the condo right next to it, like you see,
So.
sent a
Just to
testimony on that.
comment on.
One at a time.
Sorry, to comment on what you're saying too. I think there should be some middle ground with that, because what he's saying is he's holding a lot of liability with what's going on. We had an old lady that was beat up in Kimmy's parking lot and abused, and she was beat up. One of our workers, I own a restaurant that's opening in Conain. I own a bunch of different stuff, but they have a hard time and they don't feel safe walking to their cars at night because of what has happened in our town. And
Right.
so just to be able to police it with that, I think that takes liability off the county. Am I correct? And liability from him, just so he can actually be able to take it on with that public parking.
So are you-
But seeing some middle ground of what needs to happen, and that's why we're in a discussion right now.
Did you ask Claire for?
Correct, with his, would it be true he retains all liability if anything was to happen on there in those public stalls?
It's hard to make a general statement on that. There'd have to be facts to look at.
Commissioner Vatusick?
Thank you. So what the applicant is requesting
Yep.
is deleting the requirement for public parking
Yep.
with no replacement, right? Which gives them, there's a general commitment saying we want to allow parking. So to me, that's here. And our option of saying no is here. We're keeping it exactly as it is. And to me, middle ground is a plan that gets prepared and submitted and approved by the director. But to me, that's what the middle ground is.
I agree. And I think there is this strange question about, this requirement that it's public, but then he sort of then the county is saying we have no responsibility because you own it, but it's public. It's an interesting dynamic that because I'm thinking, well, what would prevent the applicant from posting signs that you're towed at your own expense and putting up a couple of cameras? That's a minimal expense. I guess I'm a little bit confused about exactly coming from this side all the way to this side and not saying, well, I put some signs up, I put some cameras up, and that's it. You're basically wanting to generate revenue to help you offset property taxes or other expenses, or I'm just.
Not only that, but to clean it up, keep it nice. Like the rest of the building is, I put a lot of money into the building. I painted it, I put new roof, remodeled the bathrooms, and I'm going to continue to make Kona Center a nice place. It used to be an eyesore. Now, it's come up a lot. And this is the next step in order to move forward to complete my renovations,
Excellent.
So, and to make it safe.
Then I agree, Commissioner Vatusick, that what would be beneficial for us, Mr. Fouquet, is a plan from the applicant, not a theoretical sort of idea of what he has and is thinking about.
Before I respond to that, can I didn't quite understand, your response, Mr. Ferguson, in response to Commissioner Kanua's question. So will the retention of this condition expose a county in any liability?
So that's, will the retention of this expose?
The existing condition, assuming there's some issues, like will the county expose itself by the retention of, because the county is requiring this condition.
It's been
Whether
required.
it was like 30 years or 40 years ago, or even today, the request is made. So, it's kind of like a
Then not really. I
reinforcement of
think I differ on your interpretation of, the whole, whether all that case law you talked about applies retroactively. And that's a whole this is all very complex areas of the law, and that's why I responded to Commissioner Kanuha's question, saying that in order to make a legal decision based on a fact pattern, I need very specific facts to make an opinion. And so your question, you're not my client, the board is my client. I don't really understand your question. I'll entertain your question, as much as, so ask the question again and I'll give you a
Like I know
off
that
the
like
cuff opinion.
on state law, when you require public access, there's some amount of like, I think there was a provision that absolves the landowner of responsibility for the public access in case there's any lawsuits associated with setting aside of that access. My question is like, does it necessarily apply to a parking lot? That's a requirement that's imposed by the planning commission.
Liability in what sense? Like if somebody falls down and gets injured, is the county going to be liable for that person
Yeah,
falling down and getting
because of
injured?
like,
Premises
the absence of
liability? I
any
mean,
control and all that stuff. They're the landowner. So it's like, I
Yes.
guess like, if somebody comes to your property and then you fall down, so
So
whose fault is it?
that's a very, as you know, you're not a, I don't know if you're a lawyer. I cannot remember. I know you're the former planning director. But legal minds differ on all of these very factual, complex situations. So the thing you mentioned about, who's liable for certain access issues and all that kind of stuff, that's a whole separate body of law. And it depends, that whole area, there's, various categories involved in that whole premises liability area of the law. So with this, there's a lot of gray things happening that had happened when you were the planning director at the time with this. And there's a lot of gray stuff happening today with this decision. But to answer your question, whether or not the county has liability, we don't know until something happens. And the lawyers and judges will decide it at that time. Potentially, the county is always liable, but right now it's owned by him. And there's a condition that he provide public parking. And in the past, as you said, and I think Alex said, that the county has interpreted that to mean that the public has unfettered access to that parking. Whether or not that's true today, I don't know. I haven't looked into it. I haven't provided a legal opinion. There's a different mayor. There's a different corporation council. There's different laws. I'm sure the laws have changed since 3 years. So I don't know is the answer to your question. I have to look into it. But potentially, yeah, it's possible.
If I may, Chair.
Yes.
I think part of that question is the same state statute apply to this public parking that would apply to a public shoreline parcel, right? Public shoreline access. Jean, would that be?
If I can jump in a little bit, I think what you're referring to is our recreational use statute. And that is I think it's chapter 520, although I will admit I didn't open it up. I think it's chapter 520 in the Hawaii revised statutes. And it allows that it was put in place years ago to encourage landowners to open up property for recreational uses. I'm not aware that any court has considered the recreational use statute for something like a parking lot. Its intent was to open up, like Zendo said, shoreline access, mountain trails, those kinds of things. And so it talks about the public use for recreational purposes. And like I said, I think it's rather, the whole chapter is rather untested in our courts. So there's a lot of uncertainty with regard to it. And so I don't think any of us could answer, nor do I really think it would be appropriate either for us to answer about whether it would provide any kind of protections for a parking lot.
Okay, so
Thank you. That was a clarity.
it was like a
Yes.
two-part.
Yes,
I think
Mr.
like,
Fouquet.
Commissioner Knowles had asked two-part question. So the answer to the second question is that the reason why I wanted to get at least some clarity or some understanding from the attorneys, I guess, your attorney, is that if there is some culpability on the part of the commission for this condition, then my suggestion is that like, since he's already committed himself to saying, I'll set it aside for this area for public parking, then, if to kind of like quote unquote cushion the blow, you could just, add a caveat to the beginning to say as represented by the petitioner or by the applicant, And so this is what he's representing. And so he's going to keep that area, the balance of the language is going to be, he's going to keep that area for public parking. Then the other thing, to enable him to exercise greater management of that area, it's easy to kind of craft a language that would essentially say that, if he decides to exercise control, that controls shall be submitted to the planning director, not, for the planning director for public information. I don't know, and you can ask this question of the director, whether the director would want to be in a position to say, like, whether you charge, $1 or $2 or $25, per hour, whatever have you, to be in that kind of position to negotiate what the appropriate fee should be. But the whole notion of like how it's going to be structured, what kind of improvements are going to be made and all that stuff, should he decide to exercise greater management, he can submit that kind of management plan to the planning director for the information. Then, it would be clear to the public, clear to the commission. At least there's kind of like a management plan in terms of what he's going to do. I can see an issue becomes if the director is subjected to giving approval of that plan. Now, like, you're getting into the financing aspect of it. What is reasonable? How do you charge? And so to remove that kind of like issue, but nevertheless have the public and the commission aware that there is, like these kind of controls are going to be in place. It's something that was part and parcel of the original request that we had made.
Thank you.
No, to me, it makes sense that a management plan would be approved by the director at a minimum, by the commission as a whole as a maximum. It's determining how that coastal zone will be used. And for me, this is strictly in terms of SMA criteria. The presence of public parking adds to the beneficial use of the coastal zone. And what capacity that would be in, I think we can work that out. I'd be comfortable that you guys could work that out with the director. So that's something that I would be comfortable saying, as a commission, I don't think we need to have you go back and prepare a plan and then come back to the commission. I'd be comfortable saying, why don't you guys work that out and make a good deal that works for the community and works for you? Because to me, those are our options. Is do we send you back now and say, come back to the commission with the plan? Or do we approve this with the condition saying, work it out with the director? What does the commissioners think about that?
I think it sounds reasonable. I just have a question, I guess, when we're thinking about parking in the context of the SMA or, attendant to a development, for example, like Mauna Kea Beach Hotel.
Yep.
And the parking stalls, the public parking requirement there. This notion of whether the parking is free or not, does that come into play? I'm a little bit, just don't totally understand. Those parking lots are required to be free. Is that correct?
That's
If
because
we're applying that same principle.
that's because their management plans determine that they're going to be free, right? That's part of their condition.
Right,
Yeah.
to protect access. But that same argument theoretically applies here.
It could. I mean, if you look at the development of an area like Mauna Kea Beach Resort or another big resort where they have a large development that encompasses a large shoreline area and triggers the need for shoreline access and a delegation of a public access for shoreline access. Here in this area, we don't have a large resort. We have lots of small developments that have cumulatively reached the point of causing a larger adverse effect to the environment. One of the ways that adverse effect is mitigated is by enhancing the beneficial use of the coastal zone through parking and access. And this particular parcel has a condition on that mitigates that impact for the surrounding areas. It's free for the community. So I mean, for me,
It's free.
I wouldn't have a problem charging tourists or that kind of thing, but I would rather see it have reasonable enforcement and reasonable public access free for local families, local people.
Director.
To add to the conversation,
Yes.
so it's the determination that requiring these with case law now would not be appropriate in the planning department's opinion. But because this condition exists, that there we're going for a greater discussion. I want to make sure that obviously this is a little different because this condition exists. We're just talking about that. However, this conversation can get much larger if this is the road that we're going down, and what does that look like? For example, Holiday Inn is right across the street from that. Did they have a requirement? Do we start doing that? Do we start going, how far Malca do we go? And this is a challenge. I am a surfer. I want to access the coast. I grew up here where, same thing where it's changed a lot, right? So there's a lot of challenges that we face. And so how do we, find that balance? But I'm also trying to have some guardrails on this, and also maybe even get a little from our legal side that because this condition was there. And curious too, Sid, was this condition essentially agreed to, or was it imposed?
Is that a question? Mr.
That's a question. Yeah, when this condition was put into the SMA at this time, was it agreed to or was it imposed?
That was imposed.
And so then I wonder, and again, this is greater conversation since we're going to get into it. If there was a condition that was imposed that later case law said would not be rational nexus for that, does that nullify that imposition of that condition?
Yeah.
Or does that maintain it even though it was not necessarily imposed appropriately?
I don't know. And I'm not sure I entirely understand the question.
So if this were to come in today, the question is, if this were to come in today in this place, and Holiday Inn is the best example of that because it's right there. Imposing a condition like this, I don't believe would pass the test based on case law.
Okay. I don't know entirely whether it would be evaluated under today's standards or whether it would be evaluated under the standards at the time. I will offer that some courts have recognized that a takings claim can pass from a previous owner to a subsequent owner and still be valid. So had it been a taking at the outset, the fact that the current owner bought it with that in place does not absolutely nullify the problem. It is something that some courts have recognized as something that passes from one owner to another. But that is in no way offering an opinion as to whether we have a takings today or not.
But also that doesn't, oh, go ahead.
I'm trying to figure out what framework we're working in here and where do we go with this framework, right? Based on it having been approved, I think the conversation is different. If we're going to open it up to a greater conversation around this based on the interpretation of that SMA rule, we start going all over requiring public access for parking that's not based on the shoreline.
But this doesn't necessarily set a precedent like that, I don't think. I mean, I don't know. I defer to corporate counsel for those things, but I think that if we're really getting back to what our role is as commissioners, it's really to think about, do we strike the condition? Do we not strike the condition? Do we maintain the condition with in an amended form? I think one of the problems here is that the county doesn't seem like the county's taken any responsibility for the parking. And when there's a problem, but is continuing to require the parking anyway. So we're putting the onus solely on the private property owner to provide the public parking without support from the county to help manage and control it.
Yeah.
That's where my mind continues to go. So if what it is, as Commissioner Vatusek suggests, is that we ask the planning department to work with the applicant to come up with some middle ground plan that addresses both needs, that makes the most sense in terms of our role here as commissioners. The question of sort of what kind of can of worms it opens, I think is something we are not empowered to determine or equipped to determine.
I will say, though, every action we take as a commission sets a precedent and moves us forward in that direction.
Yeah.
There's an accumulative impact to decisions that bodies like this make. That's all, yeah.
Commissioner Fatusek.
Thank you. No, and I think that this sets a good precedent for considering cumulative impacts within the SMA. Because I feel like there are lots of small parcels in that area that have cumulatively impacted the coastal zone a lot bigger than, you know, one large development would have. So to me, I think it's a good precedent that should be considered in future development within this area to create a proportional mitigation for the impact that's being created. And that, you know, requires work and planning from the planning department and figuring out what that proportional access and impact is going to be. But in the meantime, we trust you and your judgment to work out a good deal with them. At least I would. So I think if in the interest of moving forward, if I could, I'd like to make a motion.
CJ, Commissioner Kanuha wants to say something and
No,
then make a motion.
No, well, let Mike finish up.
Okay.
I was gonna jump.
Well, I just like to make a you want to?
Madam
Mr.
Chair,
Fuqua.
A motion on the floor.
there is a written motion. Yeah, okay. After hearing all of this dialogue and, you know, kind of talking to Mr. Fujimoto and, you know, hearing, you know, what Commissioner Knowles had to say to him about like, you know, how do you rope in the county so that they would be indirectly in a position to kind of help manage the situation? And I thought that was a very good point because, you know, if the director or someone approves the plan, then, you know, you have greater culpability. And, you know, if we call upon you guys to kind of help enforce, then you got to help enforce. Unlike today, you know, there's absolutely none. He's standing there all by his lonesome. So I kind of like have this suggestion then. So if you keep the condition and you kind of, it would read something like this, you know, as represented by the applicant, you know, this is to make it clear that it's nothing come directly that the commission is just being draconian about this condition, but it's kind of like as represented by the applicant. The parking stalls on the Mackay side of the proposed building shall be clearly identified as being for general public use. A parking management plan, which may include reasonable fees to address public safety enforcement and its maintenance, shall be submitted to the planning director for review and approval. And in that, like, it gives him a chance to say, and, you know, following up on what Commissioner Vitusik was saying, you know, there is a nexus. The question is like the proportionality is like, is his requirement like 20 stalls, you know, like proportional to the project? And like the nexus question, maybe it could be like 4 or 5. And then maybe you can have like a variation of like fee structure to accommodate certain time for certain users, you know, that kind of stuff. And I agree, like it's, you know, it's like the devil is in the detail and he needs some time to do it. But all of these can be incorporated into a plan that eventually gets submitted to the planning director for his review and approval. Once he gets approved, and as Commissioner Knowles has said, then you have some ownership. The county has some ownership. If there's this violation, he can call the county to tell you guys got to help us enforce.
I love it when you do that.
And I
love it when
agree
you
to
do that.
that
That's
100%.
Thank you.
My thing was I would commend the owner. I've seen what he's done to the building.
Yeah,
You know, we're trying to clean up this town.
I know.
And that's one step right there, bringing people back, creating great things with the property. And, you know, like you said, policing an area it's, you know, it's an eyesore on his property is great. And thank you, Sid, for that, because that was spot on.
Thank you.
So I think we have to restate the motion. Or-
Yeah. I will, I'll make a motion to include a condition that states.
What he said.
Would you mind reading that for me?
Mr. Fuqua, please read your.
I'll try to restate it and, okay. So as represented by the applicant, the parking stalls on the Mackay side of the proposed building, maybe you can eliminate proposed because the building is there, of the building shall be clearly identified as being for general public use, period. A parking management plan which may include reasonable fees to address public safety, enforcement, and its maintenance shall be submitted to the planning director for review and approval.
Thank you.
I will also add a condition, in condition 3.
Wait, what?
I'm continuing with my motion.
Yes,
So that's one of the conditions that I have in my motion. The other condition is for condition 3 that will say, instead of submit, shall adhere to the landscaping plan approved by whoever that was approved by. Kailua Village District Commission.
CDP.
so those two. Thanks.
Yes,
Yes, okay.
those 2 conditions. And then in addition to the last condition that was proposed by the department. So there'd be 3 conditions.
It's mine.
Do we need to restate the whole thing? Or do we all understand? We all understand. Okay,
Well,
so that,
I'll second you, Mike.
Mahalo.
okay. Okay, so is there a discussion on this or do we vote now?
I just want to make sure, I mean, I do have a bit discussion. I just want to make sure, because as I was hearing the motion, that part of this consideration is what is the county's responsibility vis-a-vis the parking lot? I don't know, that,
That's a different conversation.
okay, but it kind of came about as
But this is a
being
motion-
part of what the planning department would be considering.
But the motion that we're looking at right now, it has 3 parts to it.
I definitely
All right,
just putting it out there, because I think
Okay.
that is part of what is important in this dynamic.
I think that would be fleshed out in the approval of the plan
Thank
between the
you.
county attorneys and the
I just don't want it to just
Yeah,
not be outstated.
Be
On the
fleshed out when
record.
it comes to it.
I agree with you, Commissioner Knowles, that it should be considered in the development of this plan.
okay.
conceptually, I really like your suggestion of having a few stalls that are available for residents and then a few stalls with fee structure to offset parking and all that. Just that'd be between you guys, but I do like that proposal.
That's an
I
interesting.
told you, you really make me work hard.
Well, you do your best
It's
work.
almost over, Mr. Shuki.
Okay, so. So we're gonna vote now to amend the main motion. What?
I'm sorry, Chair. Can I get a clarification on the amount of parking? Mr. Fuki spoke to the Mackay parking, and there's been some discussion of flexibility on the amount of spaces. Is that the understanding or not?
I think that we won't specify an amount and we'll let that be developed in the plan that's proportional to the impact and that the department can approve.
Then that's kind of like our understanding. The Mackay side right now has 20 stalls. And then we're going to try to figure out like what is the so-called the proportionality question, maybe introducing a local rate versus like the evening rate and so on and so forth. So these are the variables that he's going to have to kind of like look at. But giving us time to look at these variables and submitting something that addresses their concern, that's the objective. And that's what the planning department would have to review it. And this is our representation.
Even potentially having like a shoreline stalls, like shoreline access stalls, where you've got limited few of them for shoreline access only. It's not for shopping. And then the rest of them market rate shopping stalls.
Exactly.
Yeah.
Yes, thank you.
Okay, so we're voting on the amended motion at this moment. Is this a roll call?
You're sure? You don't want a special parking spot just for?
Don't tempt him.
Yeah.
Okay, calling to roll call vote for PL SMA 2023-27. This will be approved with the amendments. So the two additional conditions that were stated, plus the one that was already on the record.
Alex, we get a point of clarification, because there was an original motion that was opened by Commissioner Knowles for an approval, and then there was a secondary motion by Commissioner Batusik to amend it. Can we go right to the main one, or can we amend, do we have to take the first motion, the second motion to amend?
We have to complete the motion to amend. first.
Okay.
My
So the
understanding?
first motion was to approve as recommended.
Right, so what we're gonna be voting on right now
Is the
is the amendment, which would specify those three conditions. It's amending the main motion.
Okay.
With the first by Commissioner Batusik and the second by Commissioner Kanuha.
So this would be Commissioner Knowles,
Viva two.
Aye.
Commissioner Paishon Dwar,
Aye.
Dela Cruz is excused. Commissioner Kanuha,
Aye.
Commissioner Batusik,
Aye.
and Chair DeFranco.
Aye.
Motion carries 5-1, well, 5 with 1 excused.
Now we're going to move to, we're back to the main. And we can still discuss it. We're back to the main, the first motion, which was an affirmative motion to approve.
So now correct me if I'm wrong, the motion would be to approve the SMA as just recently amended.
So I'll renew the motion, just so
Still
everyone
open.
knows. It's still live. Okay.
So this was,
We just need a second.
Is there any discussion about this or should we do the vote? No discussion.
I'm sorry, who moved the motion?
I originally made the motion.
And Dwight, you seconded it, okay.
Mhm.
And this is for the amended,
This is to approve the SMA. The last motion we just had that we voted on was to approve to agree on the amendments.
Yeah.
So now the motion sits before us to approve SMA with the
Okay.
3 amendments that were made, the 3 conditions. And now this vote will be to approve or deny the SMA application as amended.
okay. Okay. Commissioner Paishon Dwar,
Aye.
Commissioner Batusik,
Aye.
Commissioner Kanuha,
Aye.
Commissioner Knowles,
Aye.
and Chair DeFranco.
Aye.
That motion carries 5 with 1 excused,
Thank
5
you.
ayes and 1 excused.
All right. So you will be notified in writing from the county and you can begin your discussion. So we have one more thing on our agenda. It's a planning director's report on SMA determinations and minor permits issued by the planning director for the month of March. The report was distributed. There's nobody to testify in this. Do you have do any of the commissioners have any questions on the report? No?
No, Chair.
No, okay, so agenda items for the next meeting, the commissioners, let's see, pending presentation by the planning department about cumulative development impacts in Puaco's community. Yay. And to ask you if you have any other things that you want to hear about. Okay, so announcements, the next meeting will be May 19th. It's a Friday. So it's a little bit different for us. The pub here on Friday, yeah. May 19th here. The public can also testify via Zoom. And does the staff have any announcements? Maya?
Yes, thank you, Chair. So our next meeting on May 19th, we have approximately 7 items on the agenda.
Oh, is that
So
all?
I expect it to be a full day.
Hey, so, that's it then. Okay, no further business. We need a motion to adjourn.
Motion to adjourn.
We need a second.
Second.
The motion carries. We are adjourning. All in favor?
Aye.
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 Oh, no, no.
Thank you. She's on a roll. She's got candy. Oh, my God.